Hi, and welcome to Hull & Hull TV. I'm Suzana Popovic-Montag, the managing partner of Hull & Hull, a law firm specializing in estate, trust, and capacity litigation. I'm very pleased to be joined today by counsel to our firm, David Freedman, and by our co-founding partner, Ian Hull. Today we're going to talk about this concept of fiduciary. It's something that we hear from time to time, and I just thought it would be kind of a neat thing for us to flesh out a little bit. David, I'll start with you. What exactly is a fiduciary?
Okay, this is a fascinating subject, I think. And it's interesting, I think, both for lawyers and for non-lawyers, because you hear this word fiduciary a lot, and no one really knows what it means. And it refers to people have certain obligations to someone else. And sometimes those obligations are special obligations, and they're based on trust. So trustees, or estate trustees, are like the absolute prototypical fiduciaries. They owe duties of loyalty to people that are interested in the estate. But here's the point that often most lawyers don't understand, that don't work in this area. Not everything that they do, not every obligation that they have is a fiduciary obligation. Otherwise, they are the liability of a trustee would be so extensive that nobody would want to take up that office. And so it's necessary, I think, for trustees to understand really what the scope of their obligations are and what kind of scrutiny they'll come under to make sure that they've performed on those obligations.
And I think something that highlights the delineation between a fiduciary obligation and a non-fiduciary obligation are the specific legal protections that the courts have upheld for hundreds of years to make sure that if you are acting in a fiduciary capacity, you are backstopped or you are indemnified. You are protected from taking what are sometimes difficult steps. And an easy illustration is, of course, legal costs. A fiduciary can be exposed to that, of course, if they have acted improperly and not in a fiduciary-like manner on behalf of the beneficiaries. But if you've acted in a dutiful, loyal conduct throughout a piece of litigation, the courts will automatically say you get 100% of your legal costs paid out of the trust or the pool of money. And there's nothing wrong with that, because they want to encourage a fiduciary to continue to take on the job and take on those kinds of tough business and legal decisions.
Yeah, and not even in litigation. I mean, just in a conventional trust relationship, ongoing, where there's no breakdown between the trustee and the beneficiaries, a fiduciary, like a trustee, should have the benefit of legal advice to protect them, but to really make sure that they understand what's expected of them. And I don't think that there are very many courts that would argue with that.
And I'm sort of fascinated from time to time when a court wants to delineate between the two. And an easy way that we see it is in the estate accounting. We've talked about that in a previous episode, where a fiduciary, an estate trustee, is a lawyer, and they will take on tasks that are clearly lawyer tasks. Do the real estate deal, do a passive accounts application, or taking the litigation steps. Or then they'll take on tasks like go down to the bank and check the bank account for the status of the account, a more clerical, non-active task. And the courts will play with the roles, and they will say, okay, wait a minute, what role are you taking? What is the task that's involved? And what kind of protection and or exposure have you created for yourself that we need to help with or not help with? And in estate accounting, those are teased out in a really intricate way.
I think the other thing that is important to realize about fiduciary duties are, it's not just a matter of performing on some obligation like investment. It's not making a personal profit or not having your interest come into conflict with a client. So, say take a trustee who invests property to great profit in their own company. They lose their profit. A fiduciary can't make a profit in conflict of interest with the person that they're acting for. And so it's a concept that, whether it falls in the passing of accounts or it falls in just the regular administration of the trust, it's absolutely critical that the trustee and the lawyer that's advising the trustee understand fiduciary law.
With attorneys, I always find too that is often struggled, because someone who's acting for an incapable person, and coming back to David's point, you can't self-deal, you can't enjoy profit. Attorneys sometimes don't stay focused on the incapable enough, and they end up making decisions that are for their own personal benefits. And one easy illustration is, why would I give mom 3 visits a week with a caregiver? Because I'm going to inherit this dough. I want to give her 1 visit a week and pocket the other 2 because I'm going to need the money in 2 years. And those kinds of personal decisions that are clouded in your overall expansive role, and that is ultimately look after the incapable at any cost. Yet they take these decisions and they make it personal, and then they have acted outside their scope as a fiduciary in that kind of an illustration.
And I think that really is sort of the best example of this difference between the standard of care or the duty of care, the minimum that you're supposed to be doing in these situations, and elevating it to the duties to avoid conflicts of interest and duties of loyalty that only fiduciaries have. So thank you very much for that, gentlemen. And thank you to those of you watching for joining us at Hull & Hull TV.